The Sempe Stool wishes to make it quite clear that it will be willing to negotiate with all trespassers on the said lands within a 60-day period from now, from the date of this notice as we are now giving it, and thereafter no settlements will be entertained from anybody or entity whatsoever. That's all. Any person or persons or entities who have acquired a portion or portions of the said land from persons other than the Sempe Stool should take the necessary steps to see the appropriate authorities with their documents for the necessary formalities with the view of perfecting their titles. And I hasten to add that the Sempe Traditional Council, that is this office, is opened for all interested parties who may want to meet the Sempe Stool to have a further discussion on this notice so served. Litigation must come to an end because several court judgments has affirmed same. Ladies and gentlemen of the press, I read this press briefing related to lands and areas under the Jamestown Sempe Paramount Stool of Accra, under the authority of the Sempe Stool. As you're well aware, we are here at the Sempe Traditional Council premises here at Mpwase in Accra. The Jamestown Sempe Paramount Stool of Accra has become aware of trending voice messages, bills posted on various walls and houses within the Dama and Sakaman enclaves, and general rumors being spread or carried out by agents or subjects of the Jamestown Alata Stool, specifically the Danso Quarter, which sought to inform or informing the general public, and more importantly, occupants or licensees of the Jamestown Sempe Stool in the said areas of a current High Court judgment which has largely been pronounced in their favor, following which the Sempe Stool has only been apportioned a reduced area affecting the estate part of Dama and Sakaman. For the records, the Sempe Stool wishes to clarify same in that the aforementioned judgments titled Dan Willie, Danso, and 3 others, versus Na Akushika Umedru III, Sempe Manye, substituted by Ningmai Gongulu, the Akwashonche of the Sempe Stool, and secondly, Margaret Abbey, Then thirdly, Ni Aikai the third, Akumajing Manche. With suit number FAL 111/2/2015, presided over by His Lordship Kenneth Edhem Kujoji J., which said suit commenced in 2015 and judgment was delivered on the 15th of April 2025. We have labeled an Exhibit 1 to give you further details of all the documents that we make reference to in this press statement. The subject matter, or land in dispute, in the said judgment was a 14.08 acre land size which the plaintiffs claimed as forming part of the estate of their late father. I make reference to page 2 of the said judgment, and which particular land is situate, lying and being at Pakopora, an area adjoining Jonkobri northwards, marked and attached as Exhibit 2 in a copy of the said site plan. In the judgment in discuss, the trial judge adjudged the said parcel of land as forming part of the land described by the Mako Concession Inquiry, number 1120 GLR 1961, Exhibit 3, and the Akulache Judgment of 1963, which was restored in the Supreme Court in 1990 as Jonkobri and surrounding areas, as alluding to the Jamestown Alata Stool, and asserted that since the plaintiffs derived their roots of title from the Alata Stool, their grant cannot be said to be valid. Further, the learned judge was emphatic or specific in what he described as Jonkobri and surrounding areas, which he stated that the same comprises of Jonkobri, Emisagono, Pakopora Ponds, and Ama Kwantre. See page 48, paragraph 4, 5, and 6 of the said judgment. It is also important to note that the trial judge clearly stated that the aforementioned land, as described above, lies on the south of the Oblogo Road. See page 48, paragraph 3 of the said judgment. Again, the said Mako Concession Inquiry, a full court judgment, number 1120 GLR 1961, adjudged the Jamestown Sempe Stool as owners of Dama and Sakaman lands. You can also make reference to page 373 and 374 of the said judgment. Same was affirmed by the current judgment, which declared Dama and Sakaman as Sempe Stool land. We also make reference once again to page 48, paragraph 6 of the said judgment. The Mako Concession Inquiry stated that the Dama, Sakaman, and Mpwase are among the villages on the Sakumo lands or around the banks of the Sakumo River. We once again make reference to pages 356, 357, and paragraph 2, page 360, paragraph 3 of the said judgment. It stands to reason that the said portions of the said villages within the Sakumo or Mako lands still form part of the said villages. The same stool received compensation, just like the Alata stool, for the Mako salt concession acquisition. We make reference once again to pages 382, paragraph 4 of the Mako Concession Inquiry, as further evidence that the Sempe Stool owns land within same. It is noteworthy that the Mako Concession Inquiry remains till date the only judgment that affects the Sakumo Plain land or Mako lands, or all that piece or parcel of land stretching from Sakaman and adjoining areas, all the way to Botiano, and which said judgment is still in force. In the current judgment, I make reference to the High Court judgment. The trial judge asserted that the Sempe Stool cannot lay claim to Jonkobri and surrounding areas, that is Pakopora Ponds, Amakwantre, and Emisagono, and asserted further that in the same vein, the Alata Stool cannot also lay claim to the areas known as Dama and Sakaman, which has been adjudged to the Sempe to be Sempe villages, We make reference to page 48, paragraph 4 of the said judgment. It is important to state forcefully that above judgments particularly referenced the areas known as Jonkobri, Pakopra Ponds, Amakwantren, and Emisagono at all material times forms part of Alata Stool lands and are areas that share common boundaries with Dama, Sakaman, and Freedom. In summary, the plaintiffs in the current judgment were adjudged the owners of 14.08 acres of land only. We make reference to Exhibit 3, which we are going to make available to you after the press conference, as forming part of the estate of their late father, and same is within Pako Pura Ponds, which I had indicated earlier, that forms within the jurisdiction of the Alata lands. The Alata Stool was adjudged the owners of Jonkobri and Tunga, Jonkobri, which we all know as Tunga land, and the surrounding area known as Pakopura Ponds, Emisagono, and Ama Kwantren, which the land court patiently described as the land lying south of the Oblogo Road and sharing boundaries with Dama, Freedom, and Sakaman. The court therefore pronounced Dama, Freedom, Sakaman, and Mpwase as exclusively Sempe Stool lands. The second and third defendants were declared to have no land within the Sakumo Plains. In view of the above, the Sempe Stool has neither been restrained from accessing Dama nor Sakaman lands, but rather from the Alata apportioned areas, as the case ought to be, just like the other defendants, and also vice versa. So as they can't access ours, we also cannot access theirs. About a century ago, lands were the subject matter of litigation between the Sempe, Alata, and Akumaji traditional areas. The issues were judicially settled by various courts of competent jurisdiction. The Jamestown Stool had under it 3 quarters and divisions, namely Sempe, Alata, and Akumaji. With the creation of the Jamestown Union, the lands of the 3 became jointly owned. Internal disputes led to the disintegration of the Union sometime in 1916. The aforementioned Mako Concession Inquiry case led to the total collapse of the Union. The clamor for ownership of lands after the disintegration of the Union led to a series of litigations over the lands. One of such cases is the Ni Yao Duade Crab II and Ano versus J. A. Kwe, which said case was presided over by Justice Akolache J. In this judgment, he apportioned the various villages or settlements among Sempe and Alata. The piece or parcel of land west of Kolegono, including the Mamponse Cemetery, and all the way to Mpwase and its surrounding lands, that's Begbeise, belonging to the Sempe Stool. The poultry farm, Akuko Photo, as we popularly call it, Freedom, Latebi Okoshi, Begmete, Mamprobi, Sempe Mancha Village, Kolebu, Matayeko, and others were some of the areas adjudged to be Sempe villages. The Sempe Stool has equally exercised long and undisturbed possession over areas such as Glefe, Akwetema, and Gbegbe Ishona through its subjects and without protest from anyone or any quarter. The High Court judgment of Justice Akolache J., which we have labeled Exhibit 4, was set aside by the Court of Appeal of 1970. The said Court of Appeal judgment declared the entire Jamestown enclave as Sempe territory, exclusively. We have labeled that judgment Exhibit 5. The Sempe Stool then caused an advertisement or publication to be made in the 24th October 1970 edition of the Ghanaian Times newspaper. We have labeled that also Exhibit 6. However, on a further appeal to the Supreme Court, the judgment of the High Court was restored. We have labeled that judgment also Exhibit 7, which we shall make available to the media after this engagement. Again, after the Supreme Court judgment, the Sempe Stool caused a publication to be made on the 21st of March edition of the Daily Graphic. We have labeled that also Exhibit 8 to be made available to you. Again, of paramount importance to the Jamestown Sempe Stool is the fraudulent claim and or registration by the Ablor Mills family of Jamestown, Alata, over the entirety of the areas known as Latebi Okoshi, Mmengmete, portions of Sempe Manche Village, and Freedom. It begs to say that how can the Ablor Mills family own the Sempe Manche Village? As a result of which subjects or grantees of the Sempe Stool who have exercised overt acts of possession over the catchment area are constantly harassed by agents of the said family. Be informed that the aforementioned encroached areas by the said family still form part of Sempe lands, Sempe Stool lands, I should rightly say, since time immemorial via customary grants, overt possessions, and formal court decisions. It is noteworthy that between the Kole Lagoon and Sakumo Lagoon, there are no family lands, since the entire lands have been declared quota lands by various courts of competent jurisdiction. Further, the areas in question, Mmengmete, Latebi Okoshi, Freedom, Sempe Manche Village, have all been declared Sempe quota land by the Akulache J judgment in 1963, which said judgment was restored by the apex court of the land in 1990 and remains in force. The said family is a derivative or subject of the Alata Stool and therefore cannot lay claim to Sempe quota lands. Their purported acquisition or grant cannot be said to be valid, since their mother stool has no locus to alienate any above-mentioned areas, rendering any grant by the Alata Stool within the area invalid or defective, since the Sempe Stool has not parted with its interest over the said areas. The Jamestown Sempe Paramount Stool stretches beyond the constituencies of Odododiodo, Ablekuma, South, West, Central, and North to Anya, Sotuom, Kwashima, Kwashibu, Ablekuma, Olebu, Oshuman, Nsakina, Fise, which is under litigation in a court of competent jurisdiction, Oduma, Kwashikuma, New Tembibiamli, Odumase, Fanchiko, Odupongbehe, Sempe Amanfro, Udakweman, Pano, Obom, Aidan, Kwabna, Deba, Otuaplem, Odunklala, Kwayi, and etc. Significantly, in 1968, when the government of Ghana acquired the present-day Dansoman lands through an executive instrument, EI-27, from the Sempe Stool, and I repeat again, acquired the Dansoman lands through an executive instrument, EI-27, from the Sempe Stool and its grantees. It was the Sempe Stool that applied for compensation. And we have the documents to that effect where the Land Commission also accepts claim of the claim that was laid and their correspondence with the Sempe Stool. Consequently, compensation has subsequently been paid to the Sempe Stool and its grantees. I hasten to add that only part of the compensation has been paid. We are still waiting to receive the rest. Exhibit 9, in a letter from the Lands Commission acknowledging payment of the compensation to the Sempe Stool. The said compulsory acquisition only affected portions of Dama, Mpwase, Sakaman, Mamponse, and Freedom lands, and others. The land size acquired by the government is in extent of 1,715.14 acres and shares boundary with the Sakumo Plains or lands. Flowing from the above, it is clear that ownership of lands in Jamestown by various stools have been settled by various courts of competent jurisdiction. The various stools therefore know their boundaries and or demarcations of their respective lands per the foregoing. It is inconceivable to think that the Sempe Paramount Stool of Accra, under the able dynamic leadership of Ashigbente Ofio, Ni Adote Otinto II, the occupant of the Sempe Paramount Stool and Mankralo of the Gun State, and his retinue will stand aloof for their legitimate right to be trodden upon, trespassed, or same taken by certain persons or families or quarters. Please take notice, and notice is hereby served, that by the aforementioned Mako Concession Inquiry number 1120 GLR 1961 and Supreme Court judgment of 1990 and the judgment of Kenneth Edem Kujoji in April 2025, the Jamestown Sempe Stool remains the owner of all the aforementioned areas or villages, including the areas known as Dama and Sakaman, which said areas are part of Sakumo Mako lands. And take further notice that the Sempe Paramount Stool urges all Sempe grantees of the said areas to ignore notices on the ground that the said areas have been adjudged to be Alata Stool lands or belonging to another. No, you're not Chemadi. The Sempe Stool wishes to make it quite clear that it will be willing to negotiate with all trespassers on the said lands within a 60-day period from now, from the date of this notice as we are now giving it, and thereafter no settlements will be entertained from anybody or entity whatsoever. That's all. Any person or persons or entities who have acquired a portion or portions of the said land from persons other than the Sempe Stool should take the necessary steps to see the appropriate authorities with their documents for the necessary formalities with the view of perfecting their titles. And I hasten to add that the Sempe Traditional Council, that is this office, is opened for all interested parties who may want to meet the Sempe Stool to have a further discussion on this notice so served. Litigation must come to an end because several court judgments has affirmed same. I thank you all. We are grateful for your presence. So, at this juncture, I will now give the space to our Secretary of Legal Affairs here at the Sempe Traditional Council, or to the Sempe Stool. Eba jaje mi yagami ni eba mundi biya kumana eko mele huwe eba jale mi ficho ke ewojin koni mambi ananu shijogba nyeradon Sempe jata